Hi, I'm Patricia, and I'm going to talk to you about the various processes that are available to you in separation and divorce. And I'm also going to talk about the most frequently asked questions that I receive on this topic. It is universal that when relationships break down, which they frequently do, that people suffer a wide range of terribly negative emotions, from fear to anxiety to anger to jealousy, and that's absolutely normal. But the good news for you is that there are processes available, from the traditional court-based litigation right through to collaboration and mediation, which will assist you. So when you first come in to see me, we'll sit and we'll talk. I'll ask you questions and I'll listen to what you have to say very carefully so I can get a full picture of how things are for you, where your issues are, where your concerns are, and then together we'll talk about the various options that are available to you, and I'll make a recommendation as to what I think is most suitable for your conflict. So the first option available is the traditional court model. There is the district court, the circuit court, the high court, and most family law divorces and separations are dealt with through the circuit court. There is a need for courts. There are some conflicts that simply cannot be resolved by mediation or collaboration. The courts do a very fine job, and the good news is that even in the court system, 90% of cases that are listed for hearing in the courts will settle. Mediation is a system of conflict resolution that does not involve court. Mediator is a neutral, independent person. I'm a mediator. I've been doing mediation for many years. And mediation can take place in an environment such as this. The parties, you and your ex-partner, attend, and the atmosphere is informal. Now, the work that's done is robust, but the atmosphere is informal. It's friendly. The communication is open. The mediator is there to assist. And the mediator will guide you through the various topics that need to be discussed. The house, the children, the pensions, the outgoings, and all of this is done in a very formalised manner, although it is a very informal setting, and the results can be fantastic. At the end of mediation, if you have agreed the issues between yourself and your ex-partner, that can be drawn up into a legally binding agreement. And that can be brought to the court and ruled in exactly the same manner as a contested litigation. So you can end up in the same place with your divorce or your separation without having to have all of the acrimonious litigation. Collaborative practice is really a first cousin of mediation. It's based on the same principles. And this is an informal process in the sense that it takes place in a room such as this. Your lawyers are present. And so there are yourself and your ex-partner, your lawyer and his or her lawyer, as well as a facilitator who facilitates the discussions, operates on the basis of a very strict agenda to cover all of the topics at issue between you, and ultimately you can get to a point where, like mediation, you end up with an agreement which then can be ruled in court. During the collaboration, you will have with you in the room your lawyer, and your partner will have his or her lawyer also in the room to give you assistance. And the collaborative process will also be directed or guided by a facilitator who is a neutral third party. The collaborative process then works in a series of meetings about mediation, and you can then come to a full agreement with regard to all of the issues between yourself and your ex-partner. They can be written up into a document, and that document can form the basis of your legal divorce or separation through the courts. And the beauty of this is that you can do all of that without having to have very adversarial litigation in order to get to the same place. Because there are very long court lists, it can take 18 months to 2 years to get your case on for hearing, which is a very long time. In fact, I've seen cases to even go on longer than that. In the mediation collaboration system, generally speaking, 5 to 8 sessions of 2 hours per session should do it, spread over a period of, say, 3 to 4 months. And if the case is going to settle, it should settle within, roughly speaking, those parameters. One of the enormous strengths of mediation and collaboration is that you and your partner are in control of this, of the negotiation, of what happens at the table, and of the decisions that you and your ex-partner are making for you and your family into the future. And you get the opportunity to work with people who give you guidance, who ensure that you're in a place where you're able to be your higher functioning self, to be able to make these good decisions. And at the end of it, you produce a sustainable, workable solution for you and for your families into the future. Over the years, I have worked with people who inevitably come up with the same real worries and concerns, and frequently they would be, what's going to happen to their children? Where are they going to live? And these are universal concerns. But the good news is, in the process of collaboration and mediation, you can work with your lawyers in collaboration, your mediator in mediation, to be creative and find alternative and different solutions to enable you to solve the issues of the house and the children. You don't get that in litigation. Somebody you've never met before imposes your solution and gives you a solution. In collaboration and mediation, you can work hard with your team to try and figure out what's best to tailor-make your solution for your particular case. Collaboration and mediation are shorter processes and, as a result, are much more cost-effective. You may find yourself in a very special situation where, for example, you have a special needs child, or there's a sexuality issue, or indeed there's an illness. And if you're in conflict with your partner in those circumstances, it can be awfully difficult. And I believe that collaborative practice is the best model for you and your partner to find a sustainable, workable solution and enable you to get through a very difficult process to come to a robust agreement at the end. Whether you're a civil partner, a cohabitant, or a husband and wife, my message to you is that collaboration and mediation are very viable, robust alternatives for you to resolve your disputes with your partner.